All right, everyone. So we're going to get started now. Um, Good afternoon, everyone. My name is Jessica Harrington, and this is an introduction to Kentucky court history. I'm a librarian here in the Kentucky Department for Libraries and Archives in our research room, which is part of the archives. We're joined today by Kim Usry and Robin Blankenship. Robin is also a librarian here in the research room, and she'll be helping with any questions about the content, and Kim's going to be offering more of the technical help. So if you have any questions or problems, please make sure you put those in chat. We'll kind of take a break periodically for any questions that come up and kind of catch up a little bit. If you have any questions, the slide PDF is available in your Blackboard under PDFs and slides, so you can download that. So we had a technical difficulty there. Anybody else? Everybody else able to hear me? Okay. So the webinar is being recorded and will be available within the 1 week. And captionings are available. So if you need to, there's a pop-up in the top right corner. You can choose to turn the options on that way, or there is a string text link that is in the chat which you can use to open the text up in a different window. So any other technical difficulties you have, just kind of put those in chat. Kim will help take care of that. All right, so let's just get started. So why are court records important? For a lot of times for researchers, these can be sources of very valuable information. These can provide names, locations, relationships, sometimes things that are really hard to find beyond just the basic information that are available elsewhere. So the more common actual court records that people are more familiar with are things like the birth records, marriage records, death records, tax and records, deeds, things like that. But there are less commonly used court records that we actually are going to talk about more today. And these are the things like the order books, the case files, depositions, things where people actually had to go through court and go before a judge for things. The problem is that this court history is very complex. And sometimes these court records can be a little tricky to locate if you don't know kind of exactly what you're looking for or where to start with your search. Here's an example of a divorce deposition. Basically, this actually gives the person who's speaking, it gives their occupation, their age, where they lived. It's talking about their relationship with their sister and how long that they knew the couple that are getting the divorce. So sometimes these depositions can actually give information about a person's personality, what the witness thought of them, things like that. But the goal here is to kind of familiarize yourself with an overview of Kentucky court history. We don't really have time to cover every detail, but this is intended to be a good way of getting started. So some of the very basic common terms you're going to want to know when you get started with Kentucky court history or court history in general is just a few of the common terms that you're going to pop up. There's the plaintiff, which is going to be the first party to bring a dispute to court. This is the person that has the problem. So this is who they're going to bring it before the judge and say, I have a problem. And then the defendant is the person who is there to defend against that dispute or charge. So this is the person who they have an issue with for some reason. In a case of a criminal case, the defendant is the person who committed the crime or is being charged with the crime, and the plaintiff is actually the Commonwealth of Kentucky. Another term you're probably going to pop up a lot as we go through this presentation is jurisdiction. And this actually has two different kinds of meanings. Jurisdiction is all about the location. It's the geographic area that a court has power over, but it's also what type of case a court has legal power to hear. So some courts only had power over certain types of cases. sometimes only up to a certain dollar amount, or they could only hear criminal cases, or they could only hear civil cases. And then there's another one, and the last word is the appeal. And this is if a party is unhappy with what a judge decided in their case, they can ask a higher court, a court above that court, to reconsider that decision. Sometimes the judge grants the appeal and agreed that the decision was wrong, and sometimes they upheld it. So the appeal is for the judge to take another look at the case and decide if the lower court was correct. And some courts actually only had appeal jurisdiction, so they call that the appellate jurisdiction. So the only cases they heard were appeals. So these are pretty important terms to kind of know just when you're handling any kind of court documents. There are other terms. There are a lot of legal terms that kind of pop up, but these are the primary ones that you really want to know before you get started. Just as if you have an idea of kind of what we have here at KDLA, I kind of made a little handy visual here. So records, when they come to KDLA, come from 3 primary sources here. The bulk of them come from the circuit court. So we do have records here from the county clerks, and we also have records here from the higher courts in Kentucky, things above the circuit court. The circuit court is going to handle the local level civil and criminal cases. So these are going to be most of the records you get from the local areas. On a related note, these are the county courts. These tend to be administrative and financial, and these are actually the longest existing records we have continuously for the state. So the county clerk usually is a very long history that didn't change a whole lot. And in the higher courts, usually had statewide jurisdiction. So they weren't local specifically. In general, these mostly tended to be appeals from the lower courts to the higher courts. These also tend to be more distinct because they actually had to go through a process to appeal to these. And they're usually very separate from the local court records. The lower courts tended to get a little mishmashed in together a little bit because they were all local, and it's a little trickier to try to navigate those sometimes. Okay, so we're going to start kind of with the first 2 divisions here. So the county and the circuit. Usually when somebody comes into the research room, that's kind of where we first start with our questions. Are they going to be county records, or are they going to be circuit records? Just because these are the 2 longest running courts for the state. So to start, the county court, these are usually the records that, again, are more familiar with most researchers. These are actually usually recorded in books, and they're special purpose books, things like the wills and the deeds and the marriages. These are records that were created by the county court at the time. But the other type of books that you're going to see here are going to be the county order books. These were order books from the county court. These were going to be created and controlled by the county clerk. And usually this was actually a court that had a county judge that sat above them, or the justice of the peace that controlled them. And the county order books were what was used to look at what they did on a day-to-day basis. So when you're navigating these county court records, these books are usually kept by year, and the entries are chronological. And these entries are usually very short, very concise, and to the point. Indexes are pretty common. They're usually in the back of each book. Sometimes some counties actually created much larger indexes that covered many volumes all at once. But the problem is that some of these indexes may not cover everything, or the indexes might even be missing. Usually if you have different kinds of records like the marriage book, sometimes that's an issue. But marriage books are usually indexed for things like groom and bride's names, or the deed books are organized by grantee or grantor. So the grantee is the buyer and the grantor is the seller. But usually for most cases, these kinds of books do have indexes of some kind. So here's an example from a county court order book. So these were usually the more generic book. So everything that went before the judge was usually recorded in the order book. And these were, so examples, these are somebody being admitted to the poorhouse by the judge in the county court. So these are two different people, and by the motion of the mayor that they are ordered to the poorhouse. So usually if it's not in a special book like the marriage or the deed or the will, it's going to be in the county court order books. So they're always a good place to search if you can't find something, or if you're looking for something that's a little more vague and may not be a pretty common record type. The other court is going to be the circuit court. Now, in this presentation, we're going to cover a lot of the historical courts, and the organization here at KDLA will usually reflect the historical names, but the official control over all of these historical records is the circuit court clerk for the county. Sometimes these clerks had chosen to combine the old records into their old files, but this wasn't always the case. So sometimes when they came here, they're still labeled with their original court names. And other times they were interfiled, and knowing the original court name wasn't really helpful. But it's good to always kind of have an idea of what courts were possible at the time. So if these other courts did have records that we do have, that you kind of have an idea of where to go when you're doing some of these searches. You can try multiple places. Just like the county court, the circuit court is the other longest running court for the state. Again, this was local level, so pretty handy to know how to navigate these records. To simplify things, there in general are two different kinds of cases you're going to find in the circuit court. These are criminal cases, which is the government or the Commonwealth versus the defendant. And then there's civil cases, which is somebody or a group suing another somebody or group. Criminal cases are usually pretty straightforward. Misdemeanors are usually a very lesser charge, sometimes punishable by a fine or a very short imprisonment. But the felonies were the more serious charges, and these were usually punishable by much longer imprisonments or sometimes even up to the death penalty. So felonies were much harder, but they're usually criminal cases are easy to find because it's the Commonwealth versus somebody, and pretty straightforward for most of those. Civil cases is where it got a little complicated because people can have a lot of reasons for suing each other. So these can go by a lot of different names like equity or chancery or ordinary or common law. These are all very common names for different types of courts or different types of lawsuits that could happen in civil cases. So in general, civil cases are much more complex to research, and historically there were a lot of different courts that these could be in. So kind of keep in mind these different names of things and when you're doing your research, because they do actually come up. In general, though, we're just going to refer to them as civil cases as we're kind of going forward, just for simplicity's sake. So important to kind of keep in mind. So if you wanted to kind of navigate these kind of circuit court records, there's generally, you're going to find the major ones that people are interested in are going to be the case files. So whether civil or criminal, these are usually tend to be original records only. This is what they look like here in the archives. You'll notice that they're very fragile. They're usually in original order, and they can be very difficult to read. These are not usually digitized in most ways. They're very rarely even microfilmed. So for most cases, if people is looking for a actual lawsuit case file, they're going to have to visit the archives and come in person and go through boxes. Usually there are indexes to these lawsuits. So if you'll notice on the left-hand side of this index, it does actually say that some of these are equity cases, some of them are petitions. So just different types of lawsuits here. On the right-hand side, it gives you the date, and it also gives you like a case number and things like that. And then usually the indexes also were in order by plaintiff or defendant. So you could usually search both ways. The problem is the organization and how they decided to do that will vary from county to county. Some clerks were very specific on how they organized things, and some were a little more loose with that. So unfortunately, we just don't know what you're going to be looking at until we get to the point of actually trying to locate a case. So that's kind of what we do here in the research room, is help people try to locate that particular file they're looking for. The other record that people kind of want for the circuit court are the circuit court order books. Just like the county court, these are going to be the books that were kept as the court met, and everything that went before the judge, this is what they were recorded in. These are again recorded every year, and the entries are kept chronological, but they are usually indexed by name. So as an example, this is kind of what a criminal order book would look like for Warren County. It's a massive book. And then over on the left-hand side, you'll see one of the entries for a criminal trial that was entered into the orders. These are usually very consistent for the history of most counties. If the circuit court met, no matter if it was civil or criminal, it was usually, you're going to find order books with the information in there. This is also a very good alternative resource if you find that a case is missing from our records. Sometimes this does happen, but again, this just depended on if the case was misfiled or lost or destroyed over time. The order books are usually a really good choice because they usually include the judgment from the judge, the final decision, if nothing else. There are other types of records in the circuit court, but these may not be as easy to search or access just because they're not usually indexed, and sometimes their order may not even be chronological. So they can be a little trickier. Okay, but the question that we're going to have really here is, but how did we get here? So we have the county and we have the circuits, and that's usually how we start when we approach the research here at the research room, but there's a lot of history behind this. So Kentucky has probably nearly 250 years of legal history. We've got 4 constitutions that we've gone through, and we're at 120 counties. So as we're going forward, we're going to talk about how our judicial system has kind of developed over the years and how that's kind of affected the layout and the storage of some of these records, and what kind of information you're going to need as a researcher going forward. But first, I kind of want to stop and see if anybody has any questions for us for this first part here. If nobody does, that's fine. I mean, I'm going to stop periodically as we kind of go through it. I know there's a lot to cover in this information. All right, so I guess we'll just kind of move on, and we'll get started with before we were even a state. So before 1792, we were still part of Virginia. So Kentucky actually had many names when we were part of Virginia. We were Kentucky Territory. We were the west part of Fincastle County. And then later on, we were actually became Kentucky County of Virginia. As a fun fact, Fincastle County, which we came from, was actually named for a governor of Virginia at the time when it was created. However, he was a British loyalist. So when the American Revolution happened, he wasn't looked too well upon anymore. So in 1776, the entire county was abolished, and they actually created 3 new counties from that. So Kentucky was one of those counties. So it's kind of interesting that they decided to abolish it, and then Kentucky became a county because of that. So as a general timeline here, in 1776, Virginia granted county status here in Kentucky. And when they did that, they actually established 2 courts here for the county. So that was the Court of Quarter Sessions and the County Court. And you'll see why the county court is so long running is because it was actually, for most counties, it was established at the very beginning. So the Court of Quarter Sessions, sorry, it's a lot of Q's there, covered misdemeanors and civil cases. So things that you think of as far as lawsuits or criminal charges, this is where the Court of Quarter Sessions handled. The county court was more administrative and financial. So making sure taxes were paid and collected and where to spend those things in the county. And then 4 years later, Kentucky County was divided up into the first 3 counties of the area, which was Fayette, Lincoln, and Jefferson counties. And as they were created, each county was invested with their own Court of Quarter Sessions and their own county court. And for each of these continued on as time progressed and the counties divided. This trend continued. So each county, as it was created, would get the same kind of counties that its parent counties had. And then in 1783, Kentucky had enough counties that they actually created a district of Kentucky. At that time, they actually created a Supreme Court for the District of Kentucky, which had the jurisdiction over all criminal and civil cases for the district. The problem was that any appeals for these civil or criminal cases had to go all the way to the Virginia Court of Appeals in Williamsburg. And unfortunately, that meant they had to go in person, which was a very long trip and not exactly an easy journey. So this ended up being one of the main reasons for Kentucky becoming a state, was just because of the sheer distance people had to travel to get justice for some of their cases. Okay, but locating these pre-1792 records is fairly simple in some ways and a little tricky in others. The local court records, the Court of Quarter Sessions and the county court records, those stayed with the counties. So once Kentucky became a state, they didn't go anywhere. They just stayed with the locations that they were already in. The Virginia Supreme Court for the District of Kentucky, however, since we were no longer part of Virginia, those records and jurisdictions were actually moved to the Kentucky Court of Appeals. And also any cases that were still in progress in the Virginia Court of Appeals was moved to the Kentucky Court of Appeals. So Kentucky became its own state, and they got all of the records that had to do with their own areas. Okay, but there is one problem with all of this, though, is that records can be lost and destroyed, and this unfortunately was a while ago. So many courthouses over time have had disasters, fires and floods, etc. But the problem is that the oldest records tend to be the most fragile. And so if they had some kind of a disaster, these might actually be the first records that were lost. So it's a little tricky when you go back into the late 1700s, early 1800s, because sometimes these records don't even exist anymore for various reasons. So it's always good to have that expectation in your mind that this may not be even existing even anymore, even if you know it. As another example, the Court of Appeals itself had a fire in 1864, which actually destroyed all of the case files. So what we have for the Court of Appeals before that time is only the judgment reports for most of the cases. So the final decision that the judge made in the Court of Appeals for those. So even if we know it went to trial, sometimes those records don't always exist anymore. Okay, so Kentucky becomes a state, and we need our first constitution. So delegates for the Constitutional Convention for the first one, they didn't have a whole lot of political experience, so they were very much in the experimental phase. So they planned on this actually being an experiment. They just kind of took what they liked from like the Pennsylvania Constitution, which is actually what our first Constitution was very heavily based on. And they established what they thought was necessary, which was the Court of Appeals. And then they kind of decided that the legislature could establish any other courts it thought were necessary. And then they continued the local courts that are already existing from Virginia. And then they said, we'll change it in the future if we need to. So That's kind of how the first Constitution was written, and it didn't last very long because they basically planned for it to do it that way. So, the courts under the first Constitution, we have the Court of Quarter Sessions, continuing from Virginia. So this was the county level court, and it was continued from the established courts from when we were Virginia. So any counties that existed before we were a state continued after we were a state, and they kept the records from before. These were staffed by 3 justices of the peace that were appointed from the county, and they had trial jurisdiction. So they held cases, they covered cases that needed trials. So any civil case that needed to be heard before the judges, misdemeanors and minor criminal cases. These were the Court of Quarter Sessions cases. There was also something called a justices court. So a justice of the peace could individually settle a minor civil matter, or they could determine if criminal charges were necessary and they needed a full court. Any kind of civil appeals from these justices courts were actually made to the county court, or they could go to the Court of Quarter Sessions, but it was usually the county court where they appealed them. This wasn't a very long-lasting court after we became a state, as by 1802 to 1803, they actually started slowly dismantling them and replacing the Court of Quarter Sessions with the circuit court system. That's actually not until further into our second Constitution that started to happen. The other local court that they had is the county court, again continued from when we were Virginia. These were also staffed by the Justice of the Peace from the county, and their jurisdiction was specifically over the administrative and the financial matters of the county. So if it had to do with money, how to track it, how to collect it, and where to spend it, this had to do with the county courts. So anything to do with property inheritance, like wills and estates, deeds, marriages, taxes, that's kind of what they handled, who owned property and how much money did they owe the tax for it. Then public welfare and public infrastructure was where did they spend this kind of money. So poor houses, or issuing bonds and licenses, or appointing public officers to oversee certain things. They also maintain public infrastructure like the mills and roads, ferries, jails, public buildings, things like that. So this is kind of another reason they collected the taxes and then spent it. So this is the county courts specifically. But they could hear, occasionally they might hear the minor civil stuff if it had to do with like a will or estate or things like that, or something to do with the tax. They did sometimes settle minor cases or issues before them in that. And that's where the county order books are pretty helpful. Now, the thing to keep in mind between the Court of Quarter Sessions and the county court is that at this point, Kentucky was still very rural. We had very small communities. There was long distances to travel between these, and most travel was probably on horseback or by foot sometimes if it was particularly troublesome. So that meant that when a justice decided that a criminal trial was necessary, it was a little bit of work for all the judges to kind of meet up and get together to hold court. So for the Court of Quarter Sessions, they held court quarterly, so 4 times a year, and then the county court only met every month. So unless it was actually a month where the Court of Quarter Sessions was already meeting. So they only met probably 12 times a year total. So it wasn't very often. And then you had to bring all your issues to court and take care of it all at once. In general, the county courts continued until the 1970s. So as we go, they're going to keep being mentioned, but their primary jurisdictions don't really change over time. So just kind of keep that in mind as we go. They're going to be mentioned a lot, but they don't really change a whole lot either. All right, so moving on from the lower courts, we're going to talk about the higher courts now that were established at this time. So the first one is the Court of Appeals. This was the highest court in Kentucky, and it had statewide jurisdiction, so the entire state was under its jurisdiction. Most of the time, these cases that it handled were land disputes at the time. People who were coming into Kentucky and trying to define where their land boundaries were and who had rights to particular pieces of the land. The problem is there's other things that there were no options for criminal appeals. So before, at this point, you couldn't appeal a criminal decision at all. Your punishment was your punishment, and that was it. And then in 1795, it had a small minor change in it. Its jurisdiction was actually limited to just the appeals. It didn't hear the land dispute cases. Originally, all those land dispute cases were actually moved to the district courts that were created at that point. But in general, when it started out, civil appeals and all the land dispute cases, and everything that came from the Supreme Court for the District of Kentucky as well. So they had a lot on their plate at first, and they kind of took off the land disputes into the district courts a little later. The other major court that was created statewide was the Court of Oyer and Terminer. This was the only court with felony criminal trial jurisdiction. So the Court of Quarter Sessions could handle the small misdemeanor stuff, but if it was a felony criminal trial, they could not do it. It had to go to the Court of Oyer and Terminer. The Court of Oyer and Terminer met twice a year. And then the local justices would hold special examining courts to decide if criminal charges were needed for a particular crime. So if it was a smaller charge, they would probably hold them in county jail until the next Court of Quarter Sessions. So, and then a little more recent, a little more common occurrence there. But if it was a very serious felony charge, they would hold them in a state jail until the next Court of Oyer and Terminer. But since the Court of Oyer and Terminer only met twice a year, that might be a very long wait. The thing about the Court of Oyer and Terminer is these decisions were final. There were no options for appeals. And that's because, again, it was all criminal trials and there was no criminal appeal option. But ultimately, this court was actually pretty unsuccessful for the time. The judges were considered mediocre and they were often underpaid. So they didn't do a whole lot. And they were actually replaced really quickly in 1795 by the Franklin District Court. So they actually only lasted about 3 years. And in general, actually, very few of these records even still exist at all. I think we have just a very few books even existing for this particular court. So very short-lived court, very few records. So the biggest change that happened in the first Constitution was in 1795, where they kind of decided that what they had first done wasn't really working for them. So they redid the court system, and they actually divided Kentucky into several geographic areas. I've got a list of all of the different districts on the next slide. So if you wanted to look at what the existing counties were and what districts they were in, that's in the next slide. But in general, the districts courts, they held trial jurisdiction, so they could hear all the major civil cases, and they could hear land disputes from the Court of Appeals, which is when they took that over from the Court of Appeals. So they could hear people who were arguing about land within their district. They didn't have to go to a state court to argue about something that was relatively local to what they were discussing. When it first created, the Franklin District Court directly replaced the Court of Oyer and Terminer, and they became the only criminal court with statewide jurisdiction. But this didn't last long, and in 1796, they actually gave the criminal trial jurisdiction to all the all the district courts. This delay tended to have to do with the fact that there weren't very many local jails and prisons for the district courts to hold people for criminal trials. So it was actually pretty hard to hold somebody who was accused of a crime for really long periods if you didn't have a jail to do it in. So they didn't give out the criminal trial jurisdiction until 1796, about a year later. So While this was created in 1796 as a replacement for what came before, again, this didn't last very long, and it was actually replaced within a few years by the circuit courts later on under the second Constitution. So again, here's that list. If you all download the slides, you can peruse it as you need. These, I believe, were the existing counties at the time. The Logan district was added and a few years later because the Logan County was pulled out from the Nelson district, which include Jefferson County, and Jefferson is a much larger county. I think it's a very much more urbanized area relatively for the time. So as the populations grew, they kind of had to start dividing things out a little bit more. Okay. So in general, though, the district courts were above the Court of Quarter Sessions and the county courts, but they were below the Court of Appeals. So that's kind of the important thing to remember about them. They were kind of in between. So because they were in between, they did create a district general court, which was created as part of the district court system, and it was meant to be a coordinating body for all of the district courts. So it was kind of above them, really part of them, and it was meant to kind of oversee them. It was just above them. It was like a committee of the judges from all the districts. They met in Frankfurt, I think twice a year, and they held court, and it was meant to be cases that a single district probably shouldn't have control over, things like questions of law, or if there were cases against public officers or judges, or if there was a claim against the public treasury, or if it was a matter involving people who didn't actually live in Kentucky, so disputes against people who didn't live in the state, and then as well as some of the land disputes actually from the district court, if both parties agreed to take it to the general court. So it was actually replaced later on in 1802. However, it was replaced by a court, also called the general court. So in general, it kind of, this is the district part of it. It was over the district courts. The later one was over the circuit courts, but they have the same name. So it gets a little tricky trying to just differentiate between the two of them. But overall, in time, they kind of blend together, and the differences are very minor. Okay, so in summary, the first Constitution. So this is kind of a quick summary of how they began in 1792 and then how they changed in 1795. So this is the kind of courts that existed locally and in the intermediate and then the higher courts. So again, the first Constitution was very much an experiment, and they kept trying new ways to organize the judicial system as our population really started to grow with new people coming in. So I guess I want to take a second and see if anybody has any questions so far about our first Constitution. I know it's a lot really quick. They decided to make a lot of changes very fast. Okay. All right. We'll keep going with our second Constitution. Okay, so after less than a decade as a state, it was decided that they needed to draft a new constitution. These delegates were actually much more confident in their creation, so they actually made it even more difficult to make constitutional changes going forward because they wanted to keep it as the way they created it. The biggest impact on the judicial system from this constitution was that it gave legislature the power to abolish the district and court of quarter sessions and replace it with the circuit courts, which they actually did do in 1802. So not immediately, but soon after, they did replace them. But again, it continued the county court. They didn't change. It actually even increased their power a little bit, so they actually had power over their county officer appointments. Before that, I believe it was the governor had to appoint officers within the county. Sorry. So when the circuit courts were first created, they were replacements for the district court system. The courts of quarter sessions were also gradually replaced slowly as each county established a circuit court. But when they were first created, they covered multiple counties. So the judges would travel around the counties holding court, which is where the circuit part of their name came in. They kind of traveled in a circle, a circuit. And then again, as they kind of created these circuit courts, they began to phase out the quarter sessions. So, and eventually each county had its own circuit court. So by 1803, every county had a circuit court. The circuit court actually continues to this day with some very small changes over time. We'll kind of discuss those as we go. But over 200 years of records for a particular county, this adds up. And this is both civil and criminal records. So there are a lot of records for the circuit court. All right, and the circuit court also created a general court, which was meant to be a coordinating body for the circuit courts. Just like the district had one above them, this was the general court for the circuit courts. This was very similar to the general court from the district. Basically almost the same. It was just the circuit court instead of the district court. The general court ends up continuing until 1850. Majority of their cases are actually land disputes. People who were unhappy with the decisions made on when they had land cases, this is where they would bring them, would be the general court. So they had a lot of land disputes in their cases. All right, the last major judicial issue of this particular time and this particular constitution was actually the old court, new court struggle with the Court of Appeals. So how this worked was in the 1820s, there was this major economic depression from 1819. They were still recovering. And so these pro-debtor relief party finally got elected as a majority to the legislature, and they passed a bunch of debt relief laws. The Court of Appeals decided that the laws violated both federal and the state constitutions. And so the legislature kept trying to remove the justices from the Court of Appeals because they didn't like what they decided. And finally, in 1824, they just completely abolished the Court of Appeals at the time, and they created a brand new Court of Appeals with judges that agreed with them. The problem is that the old Court of Appeals officials decided that they weren't going to leave their offices. So they just continued to hold court. So from 1824 to 1826, Kentucky had 2 Supreme Courts that were giving decisions that the other court refused to recognize. And it wasn't until 1826 when an anti-debt relief party took back control of the legislature and they abolished the new court and invalidated all of its decisions. But for a good chunk of the 1820s, there was people appealing cases to both Court of Appeals, sometimes for the same case. So it made things a little tricky to navigate the legal system during that time. Okay, so second constitution, quick summary here. And you'll notice that I've also listed several other courts underneath the local courts. These are things like the police court, a city court, a chancery court, things like this. These were usually being established in larger cities like Louisville or Lexington, where the large number of people in these areas just required more courts to even handle the caseloads. We're not going to cover each one of those specifically just because they are very location specific. But just know if it was a very urban area that you're trying to do research, there might be more courts than just what we're covering. It just kind of depended on the city. But overall, while the Constitution had good intentions when it was created, by the 1850s, there was strong support for a new Constitution to kind of address some issues that had arisen in the years in between. So, anybody have any questions so far? We're covering quite a lot pretty quick, I know. Okay, I'm keeping going. All right, so the third Constitution was created in 1850. So they kept some things like before, like the Court of Appeals, the county courts, the circuit courts, things like that. They did abolish the general court, so they just kind of got rid of it completely. And then another major change that's coming in this particular time period is felony criminal cases would soon have the option to appeal to the Court of Appeals. And this was actually the first time in state history that this became a thing. But when they created the third Constitution, there were some concerns about the quality of the justices of the peace in these local lower courts. Unfortunately, most of these justices were not formally trained in law, and some of them couldn't even actually read or write. So it made some people were just not very confident in how knowledgeable these judges were for their particular cases. So because of this, they actually created the county judge position to oversee the local courts. At the same time, the Constitution actually also required that all judges be lawyers. So they had to be trained and they had to be knowledgeable of the law. So the county judge would preside over both the quarterly court and the county court. We'll cover the quarterly court in just a second. And then with the justices of the peace from the county, they actually made up a court of claims for the tax and fiscal stuff. So essentially, the county judge became pretty much the most powerful position in the county. And this is because he held political power, judicial power, and financial power all at once. The county court kind of continued as it was. It didn't really change as far as jurisdictions, just the county judge was overseeing it this time. And then they established the quarterly court. This was very similar to that old court of quarter sessions from back when in the 1790s. So the quarterly court is established in 1850. It's in between the county court and the circuit courts. And it kind of had similar jurisdiction between the two. So it could hear cases that both of them could hear. So it could hear misdemeanors, it could hear smaller civil cases, and smaller criminal cases. It was kind of meant to be an in-between. So if it was more serious than the county court usually handled, and maybe not serious enough for the circuit court, they kind of in between is where really what the quarterly court was meant to handle. Again, this was also overseen by the county judge. Okay, so finally, moving on from the local courts. So while the Court of Appeals did continue and it didn't change a whole lot with the third Constitution, as time went on, they did start having some problems. So because of this, as an example, with the passing of the 1854 Criminal Code, which allowed felony criminal cases to appeal to the Court of Appeals, the Court of Appeals caseload just began to grow, like enormously. And by the 1880s, the Court of Appeal was actually several years behind the lower courts. So the Superior Court was created at the time to kind of help take some of the cases off of the Court of Appeals. So it was between the Circuit Court and the Court of Appeals, and it was meant to kind of help lessen the workload. Unfortunately, it ended up being mostly ineffective, and the judicial process really was not sped up well enough to even make much of a dent in that caseload. It was still that behind. And so by 1890, with the fourth Constitution, it ended up being abolished, and all of the cases were returned to the Court of Appeals instead. So it was a very relatively short-lived court, not the shortest, but it didn't do the job that they wanted it to do. With this third constitution, there were also several more complications that they kind of had as time went on. So in the latter half of the 1800s, they really had, the legislature was ended up being devoting too much time to very specific legislation rather than laws that had to do with the general public or the Commonwealth as a whole. They had to pass very specific laws to handle some things just because that's how they had to do it. As an example, every town and city had to obtain its own charter from the legislature. And so these charters were not consistent. They varied in the power and limitations for each city and town based on how they applied. Sometimes the sheriffs would request special laws to be passed to extend the period of tax collection. Now, keep in mind the taxes at this time were collected by the sheriff in person on horseback. So when he needed extra time, he really needed extra time because most people were not very happy to see the sheriff come to collect taxes. Married women didn't have right over their own property, so they actually had to petition the legislature individually to control their own property. And individual counties sometimes wanted special permission to punish certain crimes. So, for example, whipping, they wanted to do a public whipping for petty larceny would be an example. Essentially, the legislature passed so many special and specific laws that even lawyers really weren't sure what the law would be for a particular subject. So it got very complicated very fast. The courts, in particular, the Constitution actually limited the number of circuit courts that it could create. So because they were limited to a very specific number, they couldn't create any more circuit courts. So the legislature had established different criminal and civil courts in some areas, especially the larger urban areas like Lexington and Louisville, because these are the heaviest populated. It's really meant to help pick up the slack and speed up the legal process, but in general, it only added to the confusion. It made the legal system much more complicated. You weren't sure which court in a particular area you were supposed to even be having a case held in. I think at this point, Louisville and Jefferson County had 12 different types of courts by the 1890s of varying jurisdictions and levels. And this is types of courts. This isn't individual courts. So there might be different areas within a type of court that met regularly. So there might be like 6 areas within Louisville that had the same type of court. So a lot of courts going on here. It got very complicated. Okay, so, but in general, while this is very complicated, the overview of most courts for that time, it wasn't nearly that bad. There was still the circuit court, there was a quarterly court, and there was a county court. These were generally everywhere locally. The justices' courts, again, was kind of a as-needed basis. And then the other courts tended to only be in the very populous, busy areas, like the police and the city courts, the common pleas, things like that. There was that intermediate court with the Superior Court in the 1880s. And then the Court of Appeals, again, at the higher courts, the highest court level. But in general, this was all that was really happening in the Third Constitution. It just got a lot more busy when you try to navigate it at the time. Okay. So, moving on to our fourth and final Constitution. So, our last Constitution was created in 1890. And by this time, constitutional changes were considered pretty necessary. So this Constitution prohibited most of the special local legislation that they had been passing before. It made sure that they could create more circuit courts. It eliminated the Superior Court and reorganized the Court of Appeals. And then it made constitutional amendments easier. So they didn't have to rewrite the entire Constitution just to make changes. So hopefully that would make it a little easier in the future if they need to make changes for where this goes. In general, though, this really didn't have a whole lot of effect on the judicial system itself at the time. It Most of the lower courts still continued just as they were. The county court, the quarterly court, the circuit court, they all still existed. They didn't really go anywhere. Their jurisdiction stayed the same. Instead, what they did is they established criteria that standardized the courts. So this usually was based on city size. So this determined which courts could exist and how much jurisdiction they had was the same for every county. The issue was that not every county or city implemented them. They were still optional. They didn't have to do the court. So there was still some variation between the counties. It just kind of depends what they decided to do and if they decided to continue something. So nothing ended. They just made everything the same if it did exist. Also, the Court of Appeals, as I said, was reorganized and the number of judges was doubled. So they gave them more judges to try and help deal with the caseload. They restricted their jurisdiction to much larger cases, or they had to fit very specific criteria to even go before the Court of Appeals. The problem is their caseload still continued to grow. It was still lagging. The Court of Appeals ended up falling even further behind the circuit courts, and the complex system of the courts that did exist, which varied between the counties, just made it much more confusing for anyone to navigate the legal system of the time. And this continued for several decades. So from 1890 to the 1970s, this is kind of how the judicial system worked. It was a lot of courts and a little bit tricky to navigate them. And if you were in a different county, it might work differently from the neighboring county. But because of all these problems, by the 1960s, sorry, we're in the 1960s at this point, they were very common, that complaints were very common at this point. But the constitutional reform just kept failing. They couldn't get it passed. So they eventually undertook a whole bunch of studies, and they asked people what they actually wanted from their judicial system. They studied what was actually happening in the judicial system, and they launched this massive informational campaign in the 1970s in order to get past a 1976 constitutional amendment. And this was meant to be the biggest overhaul of the Kentucky court system. So it ended up happening in 1977. So it passed in 76 and it went into effect in 77 and 78. So what this did, so first thing it did was it created the Supreme Court, so the Kentucky Supreme Court. And it made it the Kentucky's final interpreter of state law. So it's the highest court in Kentucky. It was created above the Court of Appeals. It had 7 justices, each elected from each geographic area, and it's held in Frankfort. And it only has appellate jurisdiction, so it can only hear appeals. And the only cases it can hear are cases of constitutional or high significance referred from the Court of Appeals, or cases that involve the death penalty or imprisonment in jail for more than 20 years. So those go directly to the Supreme Court for review. So basically, they only hear the most serious cases that need to be heard with as few delays as possible. And then next, so the Court of Appeals was updated. So they have 14 judges, and 2 are elected from each district. And these 14 judges can divide into groups of like 3 or more, and they move around to various locations throughout the state. So it lets them break into smaller groups, and hopefully to hear more cases in more locations. Again, the Court of Appeals only has appellate jurisdiction. So they only review cases that are appealed from the circuit court, and they only review decisions of administrative agencies. So all of the cases from both the Supreme Court and the Court of Appeals are managed by the clerk of the Court of Appeals. So all higher court appeals, they're all managed in one clerk's office. So they didn't have to go multiple places. It's all in one place. So finally, the lower courts went through some major changes. So the circuit courts were granted full trial jurisdiction for nearly all the cases, and all case files were transferred to their custody. So all of the lower courts were abolished, and all of their records were transferred to the circuit clerk. This was also around the time when some of the circuit clerks chose to start sending their records here to KDLA in the archives, mostly because they just had so many courts that they were getting records from. There was just a sheer number of records they had to deal with. So they sent them to us for storage and archiving. Also, when they did the overhaul of the circuit court system, they created standard case numbering for all of the circuit courts throughout the state. So there's all with the same format, same organization, same numbering system. And now, to help with the caseload of the circuit courts, they created the district courts. These are new district courts, not the old ones. These district courts are below the circuit, and they have very limited jurisdiction over very specific smaller matters. Sorry, wrong button. These were intended to minimize the number of cases heard by the circuit court. So the small claims, for example, is usually much more informal, doesn't require any lawyers, and the disputes are explained directly to the judge who makes a ruling. So overall, district courts are meant to be very small, routine matters that don't usually require a full trial. But appeals from the district court are made to the circuit court. However, all of these records from both the district and the circuit court are managed by the circuit clerk. So they're not in a separate clerk. It's all with the circuit clerk's office. Manages all of the records. So easy to locate. So to summarize, the final and current Constitution of Kentucky in its current form, essentially the 1977 amendment just simplified the court system, and it made these records much easier to locate going forward. So the Court of Appeals clerk's office manages the cases for the higher courts, and the clerk for the circuit court handles all the cases for the lower courts. So any questions so far? I know we're up to the current day. Does anyone have any questions? Okay. All right. So before we end, I do want to mention that Kentucky does have a place in the federal court system. So federal courts in Kentucky were first established in 1789. I have included a few timeline notes here for these courts, but their jurisdiction is over federal crimes. So admiral or maritime cases, land laws, revenue cases. The thing with these courts is all of these courts originate in the federal district court, and Kentucky has no control over any of these records. So if it's in federal court, they're federal records. So if you have any questions about any of the federal court records, there's a website linked listed on the slide. There's also information on where they're generally stored. So 1790 to 1979, you're probably going to find them at the National Archives in Atlanta. The bankruptcy cases specifically are at the National Archives in Kansas City. The more recent records, you're going to have to talk to the court clerk for each district. And then any appeals for the federal court went to the 6th District Court for Appeals in Cincinnati. So any questions about these, you can talk to the federal court clerks directly, or you contact the National Archives. So just want to mention those. And then finally, in summary, KDLA has probably the most court records since the founding of the state. We have most of them. So we have two different locations. We have the Archive Center, which is here in the actual KDLA building. We also have the State Record Center, which is about a mile away. It's a massive warehouse that holds more recent records. It's off-site. So some of the clerks have kept some or all of their records. So it's always good to check with the clerk's offices. But this is especially important for after 1977, when the judicial system changed and created that standard case numbering system. Cases after that point can only be found by case number. And we don't typically have any indexes for cases after this point. So these indexes are still with the circuit clerk. Even if we have the actual physical case files, we can't find them without the case number. So good to keep that one in mind if you're looking for much more recent records. Okay, and for this topic and other research guides, we do have these available on the KDLA website. I've included the link written on the slide, so if you're downloading the slide, that's where you can find it there. So you can also navigate to it and other resources for researchers by using the archives and reference button at the top of the page for the kdla.ky.gov. So you go to archives and reference, and then you select resources for researchers, and then the research guides. And there's several guides on there for researching records at KDLA. And then finally, I'm putting my contact information on the screen here. I know we're definitely over time here, but if anyone has any questions, they can feel free to email me, contact me, let me know any questions here. If you have any questions right now, feel free to put them in chat. But before we stop, I do want to say a thank you to the Institute of Museum and Library Services for providing funding and sponsoring the webinar. A link to a short survey is being put in the chat right now. Your responses are very important, and they are important for our continued federal funding. So if you could just click the link and take the survey, please. As a reminder, this webinar is recorded and will be available within the week. The slides PDF is available under the PDF and slides in Blackboard. It may not be available after the webinar, so make sure you download it if you want a copy. And then again, your certificate of attendance will be available in your learner dashboard within the week. And a thank you to our chat moderators, Kim Usry and Robin Blankenship. And I want to thank you all for attending. I know there's a lot to cover here. So.